This series discusses sexual assault and contains language that some may find offensive. Listener discretion is advised. Looking through a case file of thousands of pages that span nearly the last 4 decades, there are pieces of a puzzle that slowly come together. You have to put the pieces together to see how everything fits. You can't look at anything in isolation. It's all about how A connects to B and so on. In a case as complicated as Fredrico Lobez's, that's an especially important consideration. To take it a step further, it's also about the chronology. After his conviction, there have been revelations that perhaps would be of utmost importance had there been a trial today. Of course, there hasn't been a new trial ordered in this case, so it's purely hypothetical. But I think it's still an important question to pose. If this trial were to happen today, what chance is there that the outcome would be different based on everything that's come out after the conviction? I'll come down from the hypothetical ledge here, because that's not what this episode is about. This episode is where one major piece of the puzzle connects to another major piece. I called it DNA Part 2, but it's not a revelation of the DNA itself. It's how another piece of evidence, the medical report, directly connects to the DNA. I pretty much left the medical report to subtle foreshadowing in the beginning of this series, and that's for a few reasons. It doesn't make sense without understanding the DNA results first, and this revelation didn't happen until 2014, so 7 years after the DNA hearings concluded where Fredrico was denied release, and 26 years after he was convicted. So after going through how Fredrico got convicted and how he got denied even though the DNA is not his, now we can finally talk about the medical report. Fredrico brought this up in every conversation we had, without fail. No matter what the focus of the conversation was, he always went back to the medical report.
The whole thing is they did not want to get caught with this medical report. I knew something was going on because they gave us illegible documents. This medical report is the linchpin, man, to my conviction or me getting released out of prison. Had that medical report been disclosed in the way that it should have been disclosed, I would have been free. I'd have walked out of there doing the DNA hearings.
The medical report revelation centers on a note the doctor scribbled in the bottom left corner of one of the pages. Fredrico and the people advocating for him say they had never seen this note before 2014 because the copy of the medical report they possessed was largely illegible. This note on the illegible copy was faded ink under the date and time section of the page. But the clearly legible copy showed the note in plain language. No cleaning afterwards. Last intercourse 2 weeks PTA. Weeks is abbreviated WKS, and PTA is short for prior to admission. So the victim told the doctor she hadn't cleaned herself after the rape, and the last time she had intercourse was 2 weeks beforehand. I took that information to Eric Hall, a DNA expert at St. Louis University.
Yeah, if you had that note that the last consensual sex was 2 weeks prior, right? I would not expect to see any sperm still present. 2 weeks, 14 days later, there should not be any sperm present. In a living, functioning person who's going about their daily routine, that sperm is all gone.
Hall used to be a criminalist with the St. Louis Metropolitan Police Department. He's processed hundreds of sexual assault cases in his career. He couldn't recall a case where there were sperm heads present from an act that was 2 weeks before a sample was taken.
I don't remember any cases that I was involved with where we were expecting or saw sperm heads 2 weeks after intercourse. I don't remember reading articles about that. So, I think that piece of information should have been critical for, the defense.
So, in a case where the DNA does not belong to Fredrico, and the victim told the doctor directly after the rape that she hadn't had intercourse for 2 weeks, what does that mean for this case?
Those sperm heads were probably from the perpetrator. If she's being honest and she hadn't had consensual sex in 2 weeks, I don't think I would not expect to see sperm heads from that experience.
But if the DNA collected was likely from the rape, and the test results excluded Fredrico Lobez, the contributor, why is he still in prison? From First Alert 4, I'm Matt Woods, and this is Burden of Proof. One man's fight to show he's innocent. This is a true story about how difficult it is to prove actual innocence after a jury has declared you guilty. To answer the question of why Fredrico Lobe is still in prison, we have to understand how a note the doctor jotted down on May 21st, 1988, evaded him for 26 years. We have to go through how he ended up with illegible documents before trial, how the prosecution entered into evidence at trial an undisputably legible copy of the medical report, and how that legible copy was not utilized to Fredrico's advantage when it mattered most. The irony with the medical report is that the state's position at trial and the DNA hearings directly contradicts it. Although it slightly differed in who the state suggested the DNA belonged to, their theory was the same. The collected DNA came from a prior act, and thus the results excluding Fredrico Lobe as the contributor did not exonerate him. The problem with that, though, is a clear one. She told the doctor directly after the rape that she hadn't had intercourse for 2 weeks. And if that was true, sperm from the encounter 2 weeks prior would no longer be there. Now remember that when the victim testified during the DNA hearings, she said she had sex with 3 men right around the time of the rape. One she said was a man named Fred Knox, who was later excluded as the DNA source. And the other 2 men, she claimed to not know who they were. Here's Fredrico in a prison phone call.
She couldn't have said that she had sex with other men either. That would have been proven to be false, because right there she said she hadn't had sex at all.
The report said 2 weeks, so not quite at all, but certainly a longer time period.
And this was evidence that would have destroyed the testimony of the state's key witness. That's the only witness that we had that tied me to this case.
In this case, you have to take in the DNA results and the medical report together to get a more accurate picture. Fredrico argues if the DNA doesn't belong to him and the medical report says the victim hadn't had intercourse for 2 weeks before the rape, it suggests the DNA belonged to the rapist.
If she hadn't had sex for 2 weeks prior to the rape happening and didn't clean herself after the rape happened, that evidence belonged to that rapist. It don't belong to me based off of the medical report, am I right? Truth is the only thing that changes not.
To try and understand why last intercourse 2 weeks PTA evaded Fredrico's defense for 26 years, I want to go back to July of 1988, 2 months after Fredrico was charged with rape. The prosecution and defense were in the process of discovery, handing over documents to be used at trial. One of the documents the prosecution shared in discovery was the medical report. But the copy of the medical report that the prosecution handed over during discovery was largely illegible. The words on the documents were heavily faded. Almost none of the notes could be made out. Looking at this copy, here's what I can make out of it. The age of the victim and the date on the first page, the times next to the nurse's notes. The first says 6:30, the next 6:45. And a few words here and there in the notes. I can also see the evaluating doctor and nurse's names on the last page. Everything else written on the pages is pretty much unreadable. So in July of '88, Fredrico tried to do something about it. He talked to his public defender, Andrew Hernandez. He said Hernandez told him the circuit attorney's office claimed their copies looked the same, also illegible.
We kept going back and forth over the medical reports. He said, well, she said this is all she got. And I was like, man.
And he just kind of accepted that?
Yeah, and it seemed like, man, something wrong with this picture, man. If we can't see none of this evidence, how are we going to discover this? So she said, if you don't like it, you can write our boss. So I wrote our boss.
In a one-page letter, written in cursive and dated July 9th, 1988, Fredrico asked Circuit Attorney George Peach to address the issue of the illegible documents. He couldn't use the documents to defend himself, he argued, because he couldn't read them. In the last line of the letter, he calls on Peach to make sure the prosecutor trying the case turns over readable documents. Here's that line. I'm pleading with you to force Mary Ann Medler to turn over any other clear documents in her possession so I can defend myself, because I am innocent. Respectfully submitted, Fredrico Lobe. Mary Ann Medler was the assistant circuit attorney trying the case, but her boss, George Peach, never responded to the letter, according to Fredrico. He got the letter notarized that same month. Not a week later, Fredrico wrote another letter, this time to his lawyer, Hernandez. He told Hernandez he was concerned about not being able to see the information contained in the medical reports. Andy, whatever you do, try to get a clear medical report to help us defend against these lies, the letter said. Reading those letters now is almost eerie. What Fredrico was telling the circuit attorney's office and his lawyer 4 months before his trial turned out to be true. There was highly significant information in the medical report that pointed to who the DNA may belong to. But the jury would never hear it. Before trial, Hernandez never obtained the clear copy of the medical report. Neither the defense nor the prosecution brought it up at trial. Hernandez died in 2009, so I couldn't ask him about it. So Fredrico went to trial with the illegible copy of the medical report. During the trial, the state entered into evidence their copy of the report, Exhibit 20B. This copy was distinct from the other one that Fredrico had. It was completely legible, free of defect. It's on that copy that no cleaning afterwards, last intercourse 2 weeks PTA, is clearly written in the corner of one of the pages. But the prosecution didn't ask any questions about the doctor's note during the trial. The doctor who examined the victim testified at trial, and so did the criminalist who processed the rape kit. Nothing in the trial transcripts shows the note was given any significance at all in the trial against Fredrico Lobe, in which he was convicted and sentenced to die in prison. The prosecution's theory at trial was that the DNA came from a prior act in the days before the rape. Prosecutor Marianne Medler said in her closing argument that it maybe belonged to the boyfriend, although we know today that it doesn't. Their basis for that claim was the very few tailless sperm heads that the criminalist saw when processing the rape kit. That criminalist, Joe Crow, testified that in his opinion, the sperm came from a prior act within a few days of the rape. Absent from Crow's testimony was the doctor's note saying the victim hadn't had intercourse for 2 weeks before she was raped. And to be clear, Medler never asked, and neither did the defense. And it's not clear if Crow ever looked at the medical report while making his assessment. So Medler never asked him about it, and Crow seemingly didn't factor it into his opinion on where the sperm came from. Hall, the DNA expert from SLU, said he routinely looked at medical reports when processing sexual assault cases.
Generally, I needed to know a little bit about the scenario. So I would get a little bit of background. Specifically, what I would refer to is there's typically a medical report inside the sexual assault kit from the nurse examiner who does the kit. And they check off like what kind of assault it was and if there's any pertinent information about why they took certain swabs.
The medical report in this case does include what swabs the medical staff took and a short description of the assault the victim described. But it also included last intercourse 2 weeks PTA. Nonetheless, criminalist Joe Crow testified that it was likely that the sperm came from an act more than 24 hours before the rape. He also said the few tailless sperm heads could have been the result of pre-ejaculation during the rape. When I talked to Hall about the tailless sperm heads that Crow testified to, he didn't seem to think that it was out of the ordinary in a sexual assault case.
Tails, I wouldn't be concerned about. I rarely saw tails in the sexual assault cases that I processed. I processed hundreds and hundreds of them. Very few times did I see tails. So tails fall off very quickly. So the sperm dies, the tails fall off, maybe within a few hours, something like that. So it's pretty quick. So that part doesn't surprise me. I mean, that's typical from what I saw on, all kinds of sexual assault cases that I worked.
Crow also testified at trial that there were around 4 or 5 of the sperm heads on the swab in the rape kit. Hall described to me what his process was at the St. Louis Crime Lab, which involved getting a small amount from a swab to see if there's anything there.
When I made a slide, I just rolled a little bit of that sample onto the slide. I didn't look at the whole sample. I didn't take half of it. I didn't take a fourth of it. I didn't take an eighth of it. I just took a teeny tiny part, right, to look and see if there's any potential sperm there. So, yeah, there was probably, countless times where I only saw a few sperm, but then when we went on and got a full DNA profile.
He added that it's hard to completely understand the small number without knowing how they analyzed the biological material back then.
My question is, well, how'd they make that slide that they looked at? Did they just roll a little bit of it on there? Did they just take a little teeny tiny piece of the cutting? Because remember, at the end of the day, the DNA is the best evidence. because that's what tells us whose profile is there.
One distinction to make here is that DNA testing wasn't available in 1988, so they wouldn't have been able to definitively say who it came from. But the medical report offered a pretty big clue as to the likelihood of whether the sperm came from the rapist or someone else prior to it. Somehow, it was never brought up. I identified several people involved in this case over the years that seemingly did not see the doctor's note, or didn't say anything about it. At first, I found it hard to believe that no one on Fredrico's defense had come across the material. But Fredrico has kept a record of everything in his case. He knows it probably better than anyone. And he claimed to have never laid eyes on the clear copy of the medical report. Fredrico said Jim McCloskey, the founder of Centurion Ministries who took on his case, called him in 2014 to let him know they found a clearly legible copy. Here's Fredrico in a prison phone call on how he found out.
I was actually shocked behind that. I was like, well, say what? Because he asked me, he said, dude, you got a copy of the medical records? I said, yeah, but I can't see the medical records because they obliterated with, you can barely, the documents, you can't see the documents, and we can't discover that. And he was more or less, man, telling me that, man, hey, man, we missed a big part of what was going on.
And what about Fredrico's post-conviction attorney, Scott Thompson? He was working to exonerate Fredrico in the 2000s based on the DNA results. The doctor's note would have been useful during those efforts. But he, too, claimed to have never seen the last intercourse 2 weeks PTA note. He wrote an affidavit in 2016 saying that in preparation for the first DNA hearing, he looked at all the pretrial discovery available to him. The medical reports, he wrote in the affidavit, were of particular interest because they were critical to the question of who the male biological evidence might have belonged to. Thompson went on to write in that 2016 affidavit that he was confident he never saw the note while he was representing Fredrico. If he had, he said he would have used it to contest the state's theory and to argue that the DNA could only be the profile of the rapist. It was early 2014 when Jim McCloskey said he discovered the clear medical report while visiting the St. Louis Circuit Attorney's office. He was with a defense attorney assisting Centurion Ministries on the case, and they were trying to convince the office, yet again, that Fredrico was actually innocent of the crimes he was convicted of. McCloskey told me it was when they were talking to Ed Pistacco, who represented the state in the DNA proceedings, that they discovered that a distinct copy of the medical report, a completely legible one, existed. Actually, it was right in front of them.
So we're sitting in his office across from him. He's behind his desk, and sitting on top of his desk was the medical report, a hospital report. So we picked it up, and we started reading it, and sure enough, we saw where, in clear language, he had, in a margin of one of the pages, he made note that she said that she had had sex in 2 weeks.
Pistacco has since retired from the circuit attorney's office. When I reached him by phone about this story, he said he didn't recall a meeting with McCloskey in 2014, and he declined my request for an interview for this story. So I couldn't ask him if he ever saw the last intercourse 2 weeks PTA doctor's note during the course of the DNA proceedings. And I couldn't ask him why, despite the existence of the note, the state argued to a court that the DNA came from a prior act. The other important player from the DNA proceedings was Judge Joan Berger. She oversaw the proceedings over the nearly 6-year period that it was an open matter before the court. When I reached out to Judge Berger, she agreed to review her involvement in the case. So I sent her an email with the orders and hearing transcripts from 2001 to 2007. And then, weeks later, when I reached out to her to ask for an interview about the proceedings, she declined. She told me that the record was clear and that she had nothing further to say, that she was satisfied with her 2007 ruling denying Fredrico's release. I mentioned the medical report information coming to light after the DNA proceedings concluded, and to that, Berger said she's retired, and it would be inappropriate for her to comment on a matter not pending before her. So it was another dead end in trying to ask people with direct involvement about the medical report. If you ask Fredrico, though, he argues the outcome of the DNA hearings would have been different had the note been discovered beforehand.
Because if she hadn't had sex for 2 weeks prior to the rape happening and hadn't cleaned herself, Judge Berger couldn't never made that decision and say she believed what she said.
I wondered whether something like a copier's error could account for the fact that Fredrico had an illegible copy of the medical report in the first place. Could low ink on a printer be a catalyst for a mishap like this? To that end, I can only speculate. Here's what McCloskey told me after I speculated that in an interview with him.
I have no idea, Matt. I can't account for that. It's not, all I know is that we had never seen a clear copy of that was sitting on Ed Pistacco's desk. So that clear copy, we were able to Xerox that. That wasn't a problem. Came up clearly.
Mm-hmm.
So that doesn't strike me as a very good reason for not being able to see that before.
Once Centurion had the clear copy in 2014, they used it in a petition for a writ of habeas corpus in St. Francis County, Missouri, where Fredrico is imprisoned. They were trying to get the court to consider additional evidence they found, including the medical report. In a 2015 court document, Fredrico's attorney Rick Sindel argued that the medical report amounted to a violation of the rules of discovery, commonly known as a Brady violation. That refers to the 1963 U.S. Supreme Court case Brady v. Maryland, where the court ruled that prosecutors must disclose potentially exculpatory information as part of allowing defendants due process. Sindel wrote in the 2015 court document that what you can't read in the medical report is as invisible as if it had never been disclosed. The Missouri Attorney General's office, which opposed the habeas petition, argued the medical report did not amount to a Brady violation. Its reasoning, laid out in court documents, is that the undisputedly legible copy was entered into evidence at trial. The Attorney General's office wrote in one of its court filings that if Fredrico's trial counsel had difficulty reading the medical report, he could have acquired the record through other means. It goes on to say that any alleged defect with the disclosure was cured by the state producing the legible copy at trial. The state, though, made no mention in court documents I reviewed about the significance of the doctor's note. It only made the argument that the claim of a Brady violation was procedurally barred, despite Fredrico's claims that he had never seen the information before. And in a 2016 decision on the habeas petition, St. Francis County Circuit Judge Sean McCarver agreed with the state. He ruled that Fredrico's alleged Brady violation was procedurally barred and meritless. McCarver, just like the state in its court filings, didn't include anything in his ruling about the significance of the information in the alleged violation. To this day, no court has ever weighed Fredrico's claim that the doctor's note is exculpatory information that points to his innocence. One of the major consequences of the clear medical report not coming to light until 2014 is that no one could ask the victim about it. She testified at 2 hearings during the DNA proceedings. But without the doctor's note, Fredrico's attorney didn't use it to cross-examine her. So as she testified that there were 3 other men whose DNA it could have been, there were no questions about the piece of evidence that refuted that. And no one will be able to ask the victim about it. That's because she's dead. I heard that from several people while reporting for this story, and a friend of hers confirmed to me that she died in 2018. She was the sole eyewitness in a prosecution that hinged on identification. And that's what we'll go back to next on Burden of Proof, one man's fight to show he's innocent.
But if you see this dude, he looks just like Fred.
People close to Fredrico and his legal team think another man is actually responsible for the rape. Someone who lived in the same neighborhood, who's the same age as Fredrico. They both had light skin, but there was a key distinction in their appearances.
Very light skin and full of freckles.
All of us know who they were. That's the only motherfucker in the neighborhood that's black that's got freckles.
You can listen to new episodes every Thursday wherever you get your podcasts or on FirstAlert4.com. This podcast is produced and voiced by me, Matt Woods. If you want to get in touch, send me an email, matthew.woods@kmov.com with 2 T's on the first name. This is a First Alert 4 original podcast.